Hello, it's Christine Faulkner with Cava and Faulkner, Elk Grove Living Trust attorney, Sacramento will lawyer, and I am with Cava and Faulkner. Thank you so much for tuning in to another edition of Christine's Family Wealth Secrets. So today we're going to talk about what are some of the first things that you have to do if you are the trustee of a trust. Some of those things may be different if you are dealing with the trustee who is still alive but incapacitated or they have passed away. So if you're the trustee and you're wondering what in the heck do I have to do, this video is for you because we're going to talk about some of the first steps that you need to take, probably before even talking to a lawyer, and what the lawyer can help you do in the beginning stages of a trust administration. So let's get started. So first and foremost, I'm doing this video because it seems like, sadly, I've had a lot of phone calls from either folks I don't know or past clients who've passed away, and now their trustees are stepping in, having to manage their trusts and wondering, what do I need to do? What do I need to know? So let's talk about first incapacitation. So it's been a long time since I've worked with a client where the grantor, the creator of the trust, was actually incapacitated. But when that happens, and it does kind of depend on what the trust itself requires, but generally there will be some type of incapacity provision that requires an opinion from one doctor. Maybe it's the primary treating physician, or maybe a couple doctors who have to indicate that this person is incapacitated, that they no longer have testamentary capacity. And many times the doctors won't actually say it that way, but they will say that the person is incapacitated and then can no longer make kind of legal and financial or decisions about their health any longer. In order for a successor trustee to step in generally and begin helping a grantor, the creator of the trust, after they've become incapacitated, they'll generally need to look at the trust document itself under incapacity and determine what documentation will they need to prove that the creator of a trust has become incapacitated. Once they have that, obviously they need to go secure those usually medical opinions from a doctor or several doctors, indicating the grantor can no longer handle their own affairs. Once they have that, they'll need to create a new certificate of trust, basically moving them into the position of trustee. The grantor, who is still alive but now incapacitated, their social security number is still associated with this new certificate of trust because they're still alive. But now this means that someone else is taking over the reins, taking over control. And so imagine if you were the grantor, you're incapacitated, and now you can no longer handle anything having to do with your trust. You can't handle your bank accounts. You can't handle your investment accounts. You're going to need your successor trustee to step in and begin managing those on your behalf. And most trusts indicate that while the grantor is alive, all of the assets must be used for their benefit. So really, the successor trustee in those circumstances is really just stepping in to manage the assets and make sure that the grantor is taken care of. Sometimes that might include selling assets because if the grantor is in some type of assisted living facility, maybe there's not enough money in the bank accounts or investment accounts to pay for that on a monthly basis. So a trustee might have to liquidate some assets to begin caring for the grantor from a financial perspective. So the successor trustee is going to take that new certificate of trust along with the doctor's reports to, say, the bank, to the investment company, and let them know that this person, the grantor, is now incapacitated, and as the successor trustee, they are taking over. Possibly a new account will have to be created. Possibly the new successor trustee their name will just be put on those accounts, and that will give them access to the accounts to begin either investing the money, taking over the account to pay bills, etc. And of course, the successor trustee has a fiduciary obligation to use the money in the best interest of the grantor and to use the, basically, I'm sorry, I'm trying to remember, it's just slipped from my mind, the, intelligent investor. I know that's not the right word. But, it's just, they don't have a heightened obligation to know exactly what's going to happen in the stock market. A prudent investor. They have a prudent investor standard, meaning if they're going to be investing cash in equities, they shouldn't be doing anything super risky, like investing in a hedge fund, investing in puts and calls, and that sort of commodities. But they are not vested with some superior knowledge of the stock market, but probably a good idea to work with a financial advisor to help them make prudent investments. And yeah, again, the job here is to make sure that the grantor is taken care of, and to manage the assets on behalf of the grantor. Now, if the grantor has passed away, you as the successor trustee will have to wait until the death certificate is available until you can do anything. So that's on average, depending on where you are, taking, from 3 weeks to maybe a month and a half. Once you have the death certificate, then you can actually do something with an attorney. And the process is similar, but of course you don't have to get the medical reports because the grantor has passed away. Once the grantor passes away, the trust becomes irrevocable, and the successor trustee's job is to essentially get a hold of the trust, begin executing it, gathering the trust assets, and determining who is entitled to what. So the first thing that happens is that death certificate is obtained. A new certificate of trust has to be created, but this time with a tax ID. Once the grantor dies, their social security number can no longer be used. And so a new tax ID has to be obtained in order to create a new certificate of trust, which is basically the document that vests authority with the new successor trustee to take over bank accounts, to act on behalf of the trust. And once that tax ID and the death certificate are obtained, the certificate of trust can be created and once again taken to the financial institutions and provided so that the successor trustee can then get into that account. Once again, their job at that point is to understand the terms of the trust. What are they supposed to do with the assets? Of course, if there are any creditors, you always have to make sure that creditors are taken care of. There are certain notices that have to be sent, and I'm not going to go into the detail of all of that at this point in time, but those are the initial stages of trust administration: getting a tax ID, creating a new certificate of trust so that the successor trustee can get in and begin managing the trust assets. And of course, providing a copy of the trust to the beneficiaries. Once the